Welcome to Litigation and Capital.
You're listening to Litigation and Capital with Stephen Mirsky, partner at Mirsky Corporate Advisors. Each episode, we break down high-stakes legal issues affecting companies like yours, those earning $10 to $100 million a year, so you can turn complexity into leverage and protect what you've built. My name is Kevin Rosenquist, and of course, as always, I am joined by Stephen Mirsky. Stephen, welcome.
Hey, Kevin. Thanks for having me.
Absolutely. Thanks so much for being here. We're talking about shareholder disputes today. What are the most common sources of shareholder or boardroom conflict in mid-market companies, those 10 to 50 in annual revenue?
Well, the number one issue is money. Unsurprisingly.
No.
I mean, what's happening here? So typically it's about money. Typically it's about who's getting the money. And what I see very frequently in the mid-sized business space is family disputes. So not only do we have the money issue, we have family issues, and it gets to be pretty nasty. One of my favorite things about a shareholder dispute in a mid-market company is that it's kind of like a divorce, but in a corporate setting.
Mm-hmm.
And so, typically when I'm involved in these things, it's not just one issue that has like spurred this. It's like years of resentment and animosity building.
Well, you're talking family. I mean,
yeah. And so, during the consultation calls, typically I feel like a therapist, except that I'm the one that needs to lay down on the couch. It's really interesting to learn the dynamics of the family and hear the story of what leads you to the moment of, all right, now it's time to go to war.
What do you feel typically escalates these disputes into full-scale litigation?
I think it's where a generational issue is coming into focus, where right now we have a graying population of the baby boomers. Baby boomers are selling their businesses, right? So now the kids are taking control. And the kids of the baby boomers could be in their 60s, right? So it's not like they're, necessarily young. Or it could be multi-generational factions. It could be between brothers that are one person's trying to sell off the business, the other person wants to stick around. And so you have these life cycle events that are occurring, and we need to change control of the organization, and there's a power vacuum. How do we fill that vacuum? That is a very frequent scenario that I see. The other issue I see is that you have, mid-sized companies are focused on making money. Lawyers just muck up the works. So they haven't done corporate formalities over the years, and now it's not really clear who does what the rights of the parties are, and there's a little bit of confusion. So, a party wants to take control, and another party doesn't want that to happen. So typically I see these as issues for control that arise through some sort of generational conflict.
When it comes to the procedure, I'd like to talk about that a little bit. Are there requirements that have to be met or satisfied before a shareholder or boardroom dispute can proceed to litigation?
Yes. So most importantly, you have to give notice, or you have to demonstrate futility if you can't give notice. And so that is a very high standard to show in a complaint. And so that's an inherently difficult roadblock to get over in a shareholder dispute, because the courts don't necessarily want corporations to be having structural issues. They want the structural issues to be worked out themselves. Other sorts of procedural issues that you could have depends on the bylaws or the operating agreement of the entity. If there is a dispute, is there a requirement to mediate or arbitrate before you do something? So there's mechanisms built into the documents and into the law to slow things down and temper things out. The other issue you have with a shareholder derivative suit is that the lawsuit itself is being brought on behalf of the corporation or the LLC. it is not brought on behalf of the individual shareholder, right? So the shareholder has to allege causative action that the corporation may have, right? So what's an example of something like this? Let's say that we own a real estate investment company, and let's say that the board has been mismanaging the portfolio for the last couple of years, right? I, as a shareholder, could potentially bring a breach of fiduciary duty against the board of directors because they've been mismanaging the portfolio, right?
Mm-hmm.
The issue with that is that there's a lot of defenses that a board could raise, such as the business judgment rule, and so it's a really hard scenario to get around. So you have to find something a little bit more tangible before you go over and really start alleging a shareholder derivative suit. And then lastly, another issue related to shareholder derivative suits that's procedural is in California, you have to maintain continuous ownership of the stock or membership interest at the time that you bring the shareholder derivative suit. So if you don't own, let's say you sold your stock 2 years ago and now you want to bring a lawsuit, you don't have standing. And then let's say another example, let's say you at the time you brought the lawsuit, you had stock, but then the company got bought out and you no longer have the stock. Now you don't have standing. So there's a lot of different ways to get hung up on procedure in a shareholder derivative suit.
Can you talk about the demand requirement in shareholder derivative actions and why it's often a focal point of contention between shareholders and boards?
Sure. Well, no one wants to do the demand, right? Because for reasons that we kind of just went over, if we have a mediation or arbitration agreement within the operating agreement or bylaws, well, I can just take that demand and force you to arbitrate it. Well, I don't want to spend arbitration money, or I don't think the arbitrator is going to give me a fair shot, or, so I don't want to do that. The other issue is, well, let's say that you do give the demand, and let's say that the board addresses it. Well, now you've got an issue where they've addressed it, they didn't find it valid, so we get out of it. So that's why I'm going to bring the case, and they have to show that it's futile, that the board would do it. And that's where it gets really complicated too, because showing futility is subject to a variety of tests that you have to allege in the complaint. For instance, we have to show that the board today isn't able to be impartial. Well, what if there's a change in the composition of the board, right? Is that still valid? And the answer is maybe, right? And so this is why the demand requirement is so centralized to the shareholder derivative suit. That doesn't stop a shareholder from bringing a cause of action against the corporation or against a director, right? This is an issue if we're trying to get the corporation to bring this case on against itself, basically.
Do boards use the demand process to try to delay or block claims? And if so, what strategies have you employed to either challenge or satisfy the demand requirement?
So you can satisfy the demand requirement by demonstrating futility, but it's a high bar from an evidentiary perspective. And oftentimes we won't have the evidence needed at the time we need to allege it. What a board will typically do is just send it down the rabbit hole of bureaucracy, and they'll try to suppress it. So you could create a grievance committee. You could assess in the independent grievance committee the ability to review it and come up with a determination. What would that do? Well, that would effectively raise the stakes on the complainant bringing the suit, because they would have to show that this grievance committee was also not impartial, that it wasn't well done, etc. And there's going to be a high bar on showing that, because we're going to have to get around the business judgment rule. And so that's why this demand is such a tough requirement in a shareholder derivative suit.
When a board attempts to use its control to terminate or suppress a shareholder lawsuit, such as by forming a special litigation committee or refusing to authorize a suit, what legal avenues exist to challenge that?
Again, you have to show that it's futility,
It's got to be
and
futility.
it kind of gets into this circular loop. And so long as we can make enough allegations in our complaint to survive demurrer, um, that's usually good enough. Because if we get over that hump, frequently it will settle out. But I have a trial coming up in January on this exact issue, and so it's it depends on what the legal issues are. But again, when I've been involved in a shareholder derivative suit, and we're not talking about Fortune 100 companies with giant institutional investors that are trying to exert control over the board, um, what I've seen is typically it's a family dispute that just becomes really embittered, and they're going to spend more money fighting each other than I think the value of the damages of the complaint.
Yeah. Principle, right? It just comes back to that emotion and the
I
baggage.
have a client, for instance, that they've been litigating a matter for, let's call it, 6 years or so.
Holy
Um,
cow.
they've spent over $3 million collectively litigating, when the value of the underlying business is $1 million. I'm like, what are you guys doing? So
Wow.
yeah.
Wow, that's craziness. For executives or shareholders facing a divided or a fractionalized board, how can litigation be used strategically to shift control or force a decision or even break a deadlock?
Deadlocks are interesting. We can get a court order to compel a decision. We could get a court order to dissolve the entity. Um, I think that seeking to dissolve an entity based off of deadlock or waste or fraud or something like that, that's a pretty drastic measure. And so in California, you can file that, but there's a section, I believe it is 2200 or something like that, response where you can buy out the other shareholder. So what I have done is you use this mechanism to force a buyout of the other party, and to price out the valuation, a fair value of the company. Um, and so, and it's been successful in actions where, let's say it's two partners or three partners or something like that, where they're just totally intractable. No one wants to do anything. No one's willing to spend money to get a valuation on the business. No one's but you've got another party that's saying, "Hey, I'm willing to buy you guys out." No one can agree on price. So that's one way that you can kind of force the issue and get it done. Now, if you're a CEO and you're not on the board, and you're not a shareholder, which is uncommon given the mid-sized companies, but let's say that's the case, there's really nothing you can do. You're going to be in a pretty crappy environment, and you're going to have to just deal with what you've got, trying to manage the people above you. If you're a CEO in this situation, then what I would recommend is you try to centralize as much authority as you can possibly do, so you maintain running the business, and let the guys that are fighting over ownership fight over ownership.
Mm-hmm. Yeah. Are there risks, potential rewards of pursuing litigation in these circumstances? I mean, when you sit down with clients, how do you help them weigh the different considerations?
It depends on the strategy what's the ultimate outcome that we want, and what are the facts that we have as it relates to the bylaws or some of these other things, right? It's all very fact dependent. I view litigation as a tool. So, if we can resolve something amicably, let's do it. If we
Yeah.
need to apply some pressure, we'll apply some pressure. A lawsuit is a means of applying pressure. And there's plenty of times where there's ways for us to exert control and take over a business where I don't even have to go to court. There's instances where if you let's say let's say a company hasn't been following their bylaws, and the bylaws state specifically what a party can do or cannot do, then what we can do is just issue resolutions to clarify these positions. And now you've blocked out the other players because they don't have the authority under the bylaws to do A, B, or C. And so there's all sorts of different ways that we can get to the same goal. But typically the goal is, I want control. How do I get control?
Mm-hmm.
Or the other scenario is, I want out. How do I get out and make sure I get paid my money? And so those are typically the scenarios where I see these suits come into play.
How often do these go to litigation?
Fairly frequently.
Really?
Yeah. Again, you're dealing with intractability of either a closely held business or related family members who've got a lot of history. And the moment lawyers get involved, people get upset. Right? How could you do this to me? Why would you do this? We had something, we could have worked this out. Right? And so the emotions run high, and then it gets hard to negotiate an out of court solution. So you have to go to the next phase. But to the extent that we can get control through the bylaws, I always look at that approach.
Yeah, definitely. If you can stay out of the courtroom, like you said, it's a tool, right?
Yep, that's a tool.
Yeah. All right. Well, thanks for joining us today on Litigation and Capital. To connect with Stephen or learn more about how Mirsky Corporate Advisors can support your business, visit MirskyCorporateAdvisors.com. And please don't forget to subscribe to our channel. Leave us a review. Lots more great stuff coming your way. Stephen, always great chatting with you. Thanks so much for being here.
Thank you. Have a great day.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.